Okay.
We should not.
Martin, hello. Hello, Martin.
Yeah,
Great.
Sam.
Okay.
Hi.
So, Martin, you and I have been trying to return to our Eskinme and read it more thoroughly.
Yes.
This is where we borrow everything we know about Parliament.
Yes.
Eskinme says, quote, in all cases in which members of either house are arrested, and I underline arrested, on criminal charges, the House must be informed of the cause for which they are detained. I highlight informed and I highlight detained from their service in Parliament. It has been usual to communicate the cause of committal of a member after his arrest. I highlight after his arrest. Such communications are also made whenever members are in custody. I highlight custody, to be tried or have been committed to prison for any criminal offense by a court or magistrate. Now, and this is from the 23rd edition of Eskinme. From this reading, what's your understanding? The speaker must be informed before or after the arrest, or what? When does it become necessary to require the speaker's certificate? For what purpose?
To reiterate, your question is based on the English practice and law, the English law. With that one, the straight answer is a person that's an MP will be arrested before the speaker is informed. And the point two is that even when he's arrested, I'm reading an older version of Eskinme, but it states that if the detention is brief, the speaker may not inform the House. So the speaker will only inform the House if the detention is for a longer period. Then point number three, Sam, from my reading of Eskinme, is that this privilege never extended to criminal cases. The privilege never extended to criminal cases.
Okay.
The first case where the king released an MP in 1340, it was a civil case. So the MP was in custody for death. You know, those days, even in Ghana, under our law, a person could be in prison for death. It's only in about 2007, 2008, this ex-party Paul jury case, where our Supreme Court said, no, we should no longer imprison citizens for death. That's
right.
A contract.
Yeah.
Previously, there was another Supreme Court case, but let's just say that the 2007 case, the Paul jury case, sealed it. So the context was that these MPs only enjoyed the immunity if it was for death, trespass to chattel, as we are talking about torts. You see, so it was for only civil imprisonment, not criminal.
You just mentioned that you are referencing which edition?
12th edition.
Okay. And so I just read from you from the 23rd edition.
Yes.
Which said they are arrested on criminal charges. It didn't say civil charges.
Yes. So the point I'm making is that I'm tracing the origin.
Okay.
The history of it. If you look at this one, page 98, maybe I can read portions. It says that the privilege was for civil cases, not criminal ones. So I'm supporting your point that when an MP commits a criminal offense, if we are using the English law, he doesn't claim a privilege from arrest. He cannot, because even from the origins of that privilege, it was not for criminal cases. They said in those days, it didn't extend to felonies and this in breach of surety. Those were criminal cases. I think those days, when you are talking about 1340, the criminal offenses were few. So Eskinme says those few ones summed up the criminal law. So the point is that this privilege we are talking about was never meant for criminal cases and was never taken for criminal cases. So if you trace the history, those were civil cases in which MPs owed other persons. So he owed a debt, wasn't paying, then the court, after judgment, will order that he be imprisoned.
So if an MP committed or was suspected of committing a criminal offense, they cannot claim the privilege.
Absolutely. Absolutely.
Okay, so tell us what you think informs the difference in practice as the Speaker seeks to suggest now, and the minority group in Parliament seek to suggest now, that it will appear as if when you need to arrest, you need the permission of the Speaker first.
Yeah, so the difference in the practice is that, Ghana, earlier on you referred to the proposals for the 68 Constitution, 1969 Constitution, where the framers thought that they want to insulate the MPs, right? Yeah, so that is our Ghanaian creation. That's something that was meant for civil cases. We appear to extend it to criminal cases, even though we are not sure. And I joined Professor Bochi in saying that we should leave that to the Supreme Court as to whether we really can claim it in these criminal cases, since the history doesn't support the criminal cases. But the difference going through the Speaker is that so far, I haven't heard my good Professor Dr. Ayine and then Professor Bochi refer to the Parliament Act, Act 300. It's Section 20 of it that says that if you want to execute processes, criminal or otherwise, on a member, then you apply to the Speaker. Apply to the Speaker. So may I refer to it briefly? Section 20 of Parliament Act 1965.
Right.
It says immunity from service of process and arrest. 1. Civil or criminal process issuing from a court or place out of Parliament shall not, A, be served on or executed in relation to the Speaker, a member, the Speaker or a member, while the Speaker or Deputy Speaker or member is on the way to, attending at, or returning from a proceeding of Parliament. And then let's go on. So it's like 117, 118. But let's go to the subsection 2, which says the Speaker on an application being made in that behalf may direct that paragraph A of subsection 1, that's the one I read, shall not apply to the service or execution of a criminal process specified in that direction. You see? So this is the basis for the application to Speaker. You write to him, because you see that we don't often see the certificate that much. And this law we've always used from 1965.
Right.
So you see that, and don't forget, even though it appears to be a bit contrary to Article 117, I did a case in the Supreme Court where the Supreme Court said for this green volume, the laws here, they are effective because when Justice Crabb did this work, Parliament approved. So until the Supreme Court strikes down this, it is good law. So you apply to the Speaker. So if the Speaker says he's not releasing the honorable member, then it appears it's based on the Section 20, because it says apply.
Section 20 says his permission is required.
Yes, it says. Let me read for emphasis.
Yes, go again.
The Speaker, on an application being made in that behalf, may direct that paragraph A, that's the one I read, service, execution, blah, blah, shall not apply to the service or execution of a criminal process specified in the direction. You see, so Speaker may direct. So he writes that, though, I won't release, or I'm directing that he will not be. And as I said, so until this provision is struck down, it means that apart from the Article 118 saying that the certificate, this one says he may direct. And the good difference between Section 20 and Article 117 and 118 is that in Section 20, the execution. So you see that in Article 117, there's no provision about the Speaker directing or issuing a certificate. You remember
right.
Professor Abuchi referred to that.
That's right.
But in Section 20, the Speaker may direct. So it looks like what is lacking in Article 117 is, for lack of a better word, cured in Section 20 of Act 300.
Right. And your reading again is that this is an essential point. Your reading again is that there ought at all times, as the Speaker seems to suggest in this release, be a permission from the Speaker obtained by the police or process service before arrest can take place or a service can be effected. Is that your reading?
No. The Speaker cannot be heard to say that at all. If that's the impression, I don't believe that's what he's saying. But if that is the impression, at that point, I depart with the Speaker.
The Speaker said, let me read. The Speaker said, Mr. Speaker reiterates that the immunities and privileges of members of Parliament are not absolute. The procedure for causing the arrest of a sitting member of Parliament or serving a court process must be in accordance with the Constitution. The procedure for causing the arrest of a sitting member of Parliament or serving a court process must be in accordance with the Constitution. The appropriate procedure is to secure from the Speaker a certificate that the member in question is not attending to parliamentary business. Anything short of this should not be entertained by the House.
No, that's not correct. When you read down, the Speaker reiterates also that, the letter, which seems to have been done on his behalf.
The last paragraph of that letter is 18. It says, the Speaker would want to reassure the people of Ghana that he takes seriously the oath he swore on the 7th of January 2021 by his solemn pledge to, quote, faithfully and conscientiously discharge his duties as the elected Speaker for all, as well as to uphold, preserve, protect, and defend the Constitution of the Republic of Ghana. So if you read down, this is the only thing there.
Sam, let me see if I find another paragraph. I'll make the point whilst I continue. It is that the same letter recognizes that currently some members of Parliament are being investigated and are standing trial.
That's right.
And the number is even as high as about 13. And this Speaker, Sam, he's a lawyer like you and I, older even at the bar. The Speaker cannot be, as I said, for me, I take the position that he's not saying that a member cannot be arrested at all. No. So the example we've given.
Please, Martin, let's stick to paragraph 17. The appropriate procedure is to secure from the Speaker.
Yes.
What does that mean? It says that's the appropriate procedure, and anything short of this should not be entertained.
No, okay, for now, let's say that is it. That would be wrong. I was trying to get the paragraph where, in the same letter, the Speaker admits that there are other members of Parliament who are standing trial.
That's all right. That's all right. But this is an emphatic pronouncement. That for him is the position of the law. That if there is no prior, it says the appropriate procedure is to secure from the Speaker a certificate, blah, 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 and that anything short should not be entertained.
No, that's not correct. So as I said, I'm reading the letter as a whole. So for me, because other parts of the same letter has referred to members of Parliament who are currently standing trial, my understanding is that the Speaker is not saying it's absolute, meaning that if, let's say, as I said, if the person is caught in the very act, in law we like to say in flagrante delicto, right? In the very act of committing an offense, let's say an MP pulls out a gun and shoots somebody to death. What? How can we say we would let him go home and then we go chase the Speaker for a certificate? No. Citizens arrest under Article 14, and then you look at sections 10, 12 of Act 30. citizens and the police have powers of arrest. So we will not allow such an MP to escape home. No, we will arrest him. So the Speaker's statement here cannot be a total statement of the law. I presume he's referring to cases where the MP has not been caught in the very act of committing the offense.
Should we be presuming for him? Because he's emphatic here. Why are we helping him? He's emphatic.
Yes,
this is the conclusion of his statement. So this conclusion is very important. He says, 16, that the appropriate, he says that he is reiterating that the immunities and privileges of members of parliament are not absolute. Then in the next breath, he says the procedure for causing the arrest of a sitting member of parliament or serving a court process must be in accordance with the Constitution. So the next step is he's telling us what you have to do. And he says, if you don't prior secure his permission, you are wrong. Anything short of that should not be entertained.
Yes, Sam, we are not helping him. We are just being fair to him. Remember that the letter is written in a context, and you and I know that we interpret based on certain rules. We read the document as a whole, and we look at the context. So the Speaker, Honorable Sosu's case is not about a case where he pulled a gun and shot somebody or slapped somebody. No. So you see that the Speaker's mind is not on cases where an MP is caught in the very act. Because I've already referred to the Constitution and Act 30, where ordinary citizens even have the powers of arrest, in addition to the police powers. Okay. Sam, kindly, just one last point. Let's refer to paragraph 5 of the letter. This is what he says. Indeed, the police service and other security agencies have investigated and continue to investigate members of parliament from both sides. And in all instances, the office of the Speaker has engaged and facilitated the work of the police service. Let it not be suggested per these happenings that members of parliament and parliament are not subject to the law. Voila, you see it? Voila. And I heard that there are about 13 or so MPs who are currently being investigated or standing trial, and he's been facilitating.
Yeah, so in that part, he's simply supplying us information. He's not making any emphatic, as it were, pronouncement. He's simply supplying information. So if you ask me,
that is very key. Sam, it's very key. As I said, I'm using the tools of interpretation.
No, tools of interpretation must not include someone supplying information. If he's supplying us information that some MPs have been dealt with through the process, and then he comes to make an emphatic statement that you need to come to me first to get my order, which means he's saying that even in where he's providing information, those people have only become amenable to the process because he had to issue an order allowing it. That does not sit well with your interpretation of what the law is.
Sam, great. Let me say this. So as far as I'm aware, to the extent that I don't know the details of all those 13 odd cases, I'll reserve a bit of judgment, but let me also be emphatic that so far, I don't remember any instance where it's been reported in the media that an MP was caught slapping somebody or an MP was caught running red light and all that. So far, I haven't heard. You may, if you have any, we can look at that. Yeah. So my main point is that the letter was written in the context of an MP who was not caught in the very act of committing an offense. If he had been arrested in the very act, all this cannot arise.
Okay. So the let's bring in the Sosu once more, and we need to conclude this. Yeah. And again, I need to emphasize, sometimes in this country, we obscure the issues, and the most important things, we leave them. Yeah. This matter has come up over and again. When you are discussing it, it is not because somebody wants Sosu arrested or anything like that. Yeah. Listen to the content of the discussion and let's benefit from it. Now,
Yeah.
We would now say there were 2 attempts of arrest.
Yes.
The initial one was when he was in the process of the demonstration. He says the demonstration was almost concluding or had almost concluded, but he was still there at the demonstration. That's where he says his constituents rescued him from the arrest. Then they decided rather to give him an invitation. Then the speaker was written to, and speaker refused to release him. The speaker says he's not available because Parliament has started its sittings.
Right.
Is that the right thing for the speaker to be doing?
Yes. Okay. So in this particular instance where they have written to Mr. Speaker regarding his the availability of the honorable member, all right, that is the proper context within which Article 1182 kicks in, because now, I mean, when he was, they attempted to arrest him on site and failed. Okay. In fact, even on that day, I think we're having a caucus meeting.
Yeah, he told them that after that place, he had 2 meetings of Parliament to attend to.
So we are having a caucus meeting, and he came to the caucus meeting. That was the first time he came and briefed us. But the situation where he's now in Parliament, and then they are seeking to arrest him, and they write to Mr. Speaker. That is the situation where 118 properly, kicks in. And I'm very happy that, Mr. Kwebu drew our attention to the 1965 Act, okay, because I believe that Mr. Speaker's, contention that there has to be an application to him is based upon an interpretation of that, statute, Section 20. I haven't read it, and I don't even know whether, as he is saying, I don't know whether it has been repealed or is part of the Green Book. But I also needed
it's part of the Green Book.
Okay. Yeah. I also needed to underscore one point. Just to let viewers understand that there has been a practice and procedure that has been established, not by this speaker, but by previous speakers. And in fact, it was, the Right Honorable Michael Kwe, being himself a lawyer, who stood strongly, for that practice and procedure, which is that you write to Mr. Speaker, and then Mr. Speaker makes the MP available for interrogation. And he actually insisted that the interrogation must take place on the precincts of Parliament.
Right.
Okay, so, and
Mahama Yarga testifies that he's had several locations. They've come to the
No, even, I can give you a live example. We know that some of our colleagues are being prosecuted now in respect of Sagleme.
Okay.
All right. I am on record as a lawyer for, Honorable Collins Dowda, all right, and then one of the former ministers of, of Works and Housing. Myself and Eduji Tamaklo, my junior partner in Chambers, often went to speakers,
lobby.
The speakers' conference room for the interrogation to take place. Okay, so we accompanied them, met the police there, the interrogation took place, and then the police will go back and then, write their report.
Do you understand that? Do you say that is a different situation, like Martin is trying to explain? And I had asked myself when I saw the speaker write in absolute terms, I had asked myself, imagine the speaker was conducting the business of the house.
Yeah.
And there was some scuffle in the house.
Right.
And say somebody pulled a gun to shoot at the speaker.
Right.
And the police was available, or the marshal had to help and do things.
Let's say that he shot someone else other than the speaker.
No. Will there be a requirement? Will the speaker say, hey, you can't touch that person until you get my certificate?
Okay. Yeah. So you see, it's a very interesting point that you are making. All right. If the crime is committed, on the precincts of Parliament, in the face of Mr. Speaker and other members of Parliament, the question then becomes whether or not the police can instantly arrest.
Or in the face of the police. The
police are not allowed on the precincts.
No, I'm talking about outside of Parliament. Outside of the Parliament. A member is attending.
No, I think
it's on his way to Parliament.
Okay.
And then he commits a crime in the face of a police person.
No, in that case, if he's on his way to Parliament, then 117 kicks in.
Really?
Yes, 117 kicks in. He cannot be arrested.
On his way to Parliament. So let's look at it this way. On his way to Parliament, there's a scuffle. He shoots somebody dead. We should allow him to go. We should get a certificate from Speaker.
Yes.
The immunity.
Really?
Yeah, the constitutionalization of that immunity also has legal consequences.
Yeah.
All right. So you cannot effect an arrest that is unconstitutional.
Martin disagrees with you on this.
No, I don't think so.
I also disagree with him on that aspect.
He says if the offense is committed in flagranto delicto, you must be arrested. In fact, in the framers,
if I may come in,
just let me point him to this, then we can continue there. The framers of the Constitution, in the one that I referred to in the 1968, they referred to this and said, in paragraph 433, that in order to ensure that members of Parliament are not prevented from participating in the work of the House, they should be granted immunity from arrest and detention while they are traveling to and from Parliament or while they are attending Parliament. This immunity, however, should not be made to cover serious offences such as treason, sedition, and felony, nor apply to offences in flagrante delicto.
Yes.
Meaning, we have seen you committing it.
Well, I would have preferred that we referred to the Committee of Experts report because that was what informed the content of the 1992 Constitution.
Right.
However, if the provisions in the 1992 Constitution, are impari materia, if they are the same as those in the 69 Constitution, then we can say that this analysis will apply because the Committee of Experts also referred to the report of the Commission, for the Constitution of 1969 in crafting this. And some cases where they thought that there was no need to change the substantive content, they just simply lifted them and added them to the Constitution.
All right.
So again, it's a question of constitutional interpretation, as to whether in those circumstances, we can go back to the 68 report and say the framers did not intend that, a felony be covered by the immunity or the commission of treason be covered by the immunity. Of course, treasonable acts, are acts that are intended to overthrow the arms of government.
And he said felony to felony.
Right. Okay, so in those circumstances, would you now wait? If for instance, Mr. Speaker could be part of the conspiracy to overthrow the arms of the government. So would you now wait?
So you are changing that? You are changing your position on that?
No, I'm not. I'm just simply saying that theoretically, if we were to go back to the analysis of the 68 Commission, then our interpretation of 117 should change. If that was the intention of the drafters of the Constitution.
But without that, your position is that you still need the Speaker's permission.
If he's on his way to Parliament, he enjoys that constitutional immunity.
But you said a while ago that standing in Parliament itself and engaging in the proceedings of Parliament, if somebody took out a gun and was going to shoot, you do not need to say that we need a permission before.
No. You are standing in the premises of Parliament, and then you are committing an offense, right? As I was saying, the police cannot come to the presence of Parliament. It is the Marshal of Parliament under the authority of Mr. Speaker who will arrest that person.
When the Marshal arrests the person, what do they do with them?
The person is then handed over to the police for purposes of, there will be discipline in accordance with our standing orders, first of all. But both the Constitution and our standing orders are to the effect that the fact that you have been punished under the standing orders is no bar to criminal proceedings. So you'll be handed over to the
Speaker will not give the Marshal permission to do the arrest. The Marshal must arrest.
Yes.
And once they do, they hand over to police.
Yes.
Okay. Quickly on that, and then let's see what we do.
Thank you very much. I think that it's important for us to remember that the immunity conferred under 117, 118 is what lawyers call procedural immunity.
Okay.
It is not substantive immunity, and there's a danger to confuse them sometimes. Okay. In other words, nobody in Ghana, members of Parliament inclusive, are given immunity of any kind in terms of the substantive laws of Ghana. In fact, even the president has procedural immunity. Procedural immunity means you have immunity unless certain processes are gone through. In the case of Parliament, you have immunity, if we should agree with the arguments that Honorable Dominic Ayine, for example, has proffered, you should comply with the processes of going through the Speaker before you're able to complete and effect an arrest. It is only procedural. It is only the process, not the substance. Now, in this case, I would like to just also draw attention to the fact that we need to understand that there are two kinds of arrests. We have arrests that are originating authority of the police to conduct arrest on their own. They don't need anybody to activate them. And then we have arrest pursuant to the warrant of a court. Yeah. If the court issues a warrant, what they simply do is that they shift the locus of authority, and they also then shift blame. So, for example, if the police conduct an arrest and the arrest turns out to be false, under the Constitution, the person can sue the police for compensation. And the law says that the officer involved will have to personally compensate.
Right.
If the court issues a warrant of arrest and the police effect an arrest pursuant to that, if the arrest turns out to be, the basis of the arrest turns out to be false or wrongful, you can't sue the police because they have acted pursuant. So it shifts the locus of blame and the locus of authority. Okay. But that doesn't imply that the police of their own cannot originate the authority to arrest. Now, what that means is that when the police originate their own authority, when the police commence an arrest process on their own, without the originating authority of a court, for example, that is not a process.
That is not a process?
No, that is not a process.
Okay.
It is an arrest.
It is an arrest, but I'm saying it is not. When we speak of a process, when lawyers speak of process without qualification, what it means is we are speaking of judicial processes, documents that are related to the judiciary. The police arresting someone is not deemed a process, in quote, as a term of art.
You are still confirming your interpretation of Article 117.
Correct.
That it doesn't apply here.
Correct.
The police
and if you extend it to the Parliament Act,
have liberty to just arrest.
If you extend it to the provision quoted by my colleague Martin Pegu, the issue of the Speaker having to come in.
From Section 20 onwards of the Parliament Act.
Correct. It's still very much akin to processes. Now, the reason for this, and you see the examples you were given, and Dominic explained some of the, sorry, I'm a good friend.
Don't worry.
I call him Dominic, we're good friends.
Yes.
But he's the Honourable Member of Parliament, so Honourable Dominic Ayine.
Breach of privilege.
Yes, forgive me for that. Breach of privilege. So if the examples you were given, an example that came to mind is this. If, for example, two members of Parliament engage in a scuffle, or a member of Parliament and somebody, and in fact, given recent happenings in Parliament, that is not beyond the realm of possibility. That can actually happen. If two members of Parliament are involved in a brawl, and one stabs the other, for example, and we have a major incident of an attempted murder or whatever it is on our hands, we are saying that if the police are immediately informed and they make their way, the marshal arrests, or the marshal brings them under control, and the police have to come in and complete the process. The police have to get the Speaker. If, for example, the Speaker is not on hand, the police cannot go through complete the process of arrest unless they've gone through the Speaker. That is problematic. The power of the police to arrest, as I indicated, originates from Article 14.
Okay.
And if you add that to the Criminal Procedure Code, what it means is that even on reasonable suspicion, they don't have to wait for offense to be committed in flagrante to be looked to. Once they have a reasonable suspicion, they can commence and effect an arrest. And I think that the tendency to want to restrict this, and if you allow me 30 seconds,
yes,
I promise.
I need to go to SN Dankwa quickly so that we take a break.
But 30 seconds, I mean, the 1969 provision that you referred to, the Committee of Experts, the Commission, there was a historical basis under the 1960 Constitution. The powers of the President under the 1960 Constitution were excessive.
Exactly.
And there have been criticisms of the President having exploited and abused and all that. So the 69 Constitution Commission was clearly liberal under that. And were trying as much as they could to avoid a circumstance or the tendency in which the executive, with the powers of police, can literally manipulate the legislature. Okay. So all these variables sort of played out, and that probably reflected.
Yes. And
in their
what some citizens have been asking, and Dominic, if I can get briefly on that, then I go to the venerable SN Dakwa. Members of Parliament, you are always on your way to attending to or returning from Parliament. Even in your sleep, in your bathroom, when you are in church praying, you are doing parliamentary work. Then, are you not abusing this law such that you can never be caught under, you are always living in privilege? And sometimes, even when you are on your recess, we are always told that you are attending some meeting which is under Parliament, and so nobody has access to you until, if this process has to be followed, Speaker says, go and deal with the person.
Well, you know, I come from a school of thought that says that, you know, all of us interpret the Constitution.
Right.
Ordinary citizens, you know, state institutions, officials of state, and so on. We interpret the Constitution in the course of the execution of our daily tasks and living our lives as citizens.
Right.
Until such a time that there's so much confusion about or there's conflict with respect to our various interpretations of the Constitution.
Right.
Then the only, you know, arm of government given the power to settle the dispute then kicks in. That is, the Supreme Court in this case. I think that the overextensive interpretation of the provisions, all right, it's a kind of attempt to self-preserve, okay? Because look, I mean, let's face it.
When you say overextensive interpretation,
yes.
You're talking about Parliament.
Yeah,
and
no,
MPs.
I mean, I'm talking about individual MPs or the MPs as a body thinking that even when they are in their bathrooms, as you have, you know, I mean, jokingly referred to, they are, you know, acting under privilege. All right. It is because we have a history that we cannot, you know, run away from, which is the tendency of executive abuse, you know, of power, the power to arrest and to detain. All right. And most of the time, and as Prof pointed out much earlier, usually it is the opposition that is in fear, living in fear of being, I mean, arrested and detained. And
particularly
and
this Parliament, which is divided.
That is so.
If the executive wants to abuse the power, they just need one MP out, then they can get a majority vote.
I gave that example on your Super Morning show yesterday, and I said, look, in a very evenly divided Parliament such as now, if there's a critical vote to be taken, all we need is an instruction from the President to the IGP to damperize, you know, I mean, damperize 10 members.
Okay.
And then the vote is won. I mean, without, you know, so
you don't need 10 members.
So
and I remember, is it in 2012? The police had invited, is it Kennedy Japan?
Yes.
He attended to them, and then they arrested him.
Yes.
And then
I think that was when he made the statement
those
about
comments,
you know, those comments about
which eventually bordered on misdemeanor rather than those
which also
charges.
Means that the police must start respecting these specific authorities, like invitation, like you know, if you invite someone, 90 out of 100 you don't arrest him. He's a person of interest.
Right.
But if you invite people and you arrest them, then the invitation becomes something of a trap.
Right.
And people complain about that.
Right. That's why Justice Dennis Ajay will say, as lawyers, exercise your discretion on this. Because you know often the invitation will be turned into arrest. Yeah. So why don't you let them arrest them so you can exert your rights when you are being arrested? Because when they are inviting you, you can't talk about any right. Okay, let's go to SN.
Well, hopefully things will change.
Let's go to SN Dakwa, who is on with us briefly to give us some insight into his time with Parliament and how all these things were done. It must be stated now that the police have decided that they don't want to take the blame for anything. So they have gone to the court. Wow. And the court has issued a criminal summons. So now it is the court that is chasing the MP, not the police. The criminal summons acts in a funny way. It says it can be served either through the clerk of parliament or the head of department of the public service. And members of district assembly and so on enjoy the same immunities like MPs. You can't serve them when they are on their way or they are returning or they are doing their job. But you could also take it to the person's house, ordinary resident. If you find them, give it to them. If you don't find them, you can give it to someone of apparent age of 18 and it will be deemed as service. If you can't find somebody there too, then you can post it or paste it on a conspicuous place within the premises. Or you can send it by post, as in postal process to them. And they will have to show up. If they don't, they can decide that they will send a lawyer, just write a letter to plead guilty, and the case will be dealt with without their attendance. Thank you very much, SN Dakwa, for your time. Help us briefly in the history of this parliament. You have served in the first to the fourth parliament. Has this issue always been this, as it were, heated? And how has it been resolved?
Well, thank you very much. Let me say that this immunity and privileges for members of parliament was given to ensure that members are not restricted from their performance of duty in parliament. And so, in order to prevent arbitrary arrest of members of parliament by the executive or the other authority, they say that when a member of parliament is attending meetings of parliament or going out, you cannot, arrest him, so that his duties cannot be restricted. He has to come to parliament to perform his duty for which he was voted. But it seems to me that other people take it that the immunities and privileges of members of parliament are licensed to commit crime. Let's make that emphasis clear. They are supposed to prevent crime, to ensure peace and order in the society. And therefore, if a member of parliament is caught in the act of committing crime, I think he can be restrained, taken, and then inform parliament that this member was in the process of committing this and we have got him in custody. But the speaker must be informed because he wants to ensure that members are able to attend parliamentary meetings, sessions, and so forth without any hindrance. And especially at this time when membership of the two sides are almost or are equal, if an executive does not want one side to carry a vote in favor of another one, they can, manipulate to get some members of parliament and say that he is under arrest for certain crime. You see, especially when the membership of both sides, this is 137, 137. And I give you a typical example of this bill, is it bill or motion which is coming before Parliament, that is about homosexuality. You see, the sponsors of these people who want to ensure full attendance so that they can vote for it.
That's right.
The other side also, who are opposing, they even want about 2 or 3 who do not want the bill to come. In this case, you see, the speaker must ensure that all sides are protected. Remember, there's no way you can restrict somebody from coming to Parliament to perform his duty in this way. So all that I can say is that many members would like to ensure that all sides are present in deliberation, especially about controversial issues. All sides should be present, and not a single one be absent because the executive or other authority is trying to use the other one to the advantage of the other one. So I would say that, first of all, immunities and privileges of members of parliament are not licensed for committing crime, but to preserve peace and to ensure that the work of parliament is impeded, is not impeded, so that we can have smooth peace in this country.
In this case, we have discovered subsequently that the charges against the MP are actually misdemeanors. That is to say, not exactly any serious offenses.
Yeah.
Do you think misdemeanors must be the reason that an MP, will not be given the opportunity to have the speaker release them?
Well, perhaps. If I can say anything. We have this bill before Parliament. That's homosexual bill, which many Ghanaians hate. But others also want to have it because they say it will protect individual freedom. So, if the police on its own do not inform the speaker that this thing is going to, this man or this MP has committed this crime, therefore he may be there for a long period when this particular bill, which concerns everybody in this country, is about to be passed.
Okay.
So it would have been prudent for the police to inform the speaker that this is what has happened, and we need your permission to go into it. We need your permission to carry out this in accordance with Article 117 or 118.
How should the two get to work together? Because I hear some suggest that this thing about go to court, if it gets to the court, the interpretation which will be binding might not help the cause of Parliament and the MPs. So the better way is to mutually agree on the protocol nicely so that you don't have a court giving an interpretation that will take away the manner in which the MPs are looking at it. If the speaker is written to and he says, I'm not going to release him, how should they cooperate to avoid some of these things?
Well, actually, if the speaker says that he's not going to release, he must have very good reason for doing that. In fact, I worked with this speaker for a long time, and I know he's a very, reasonable person. If he knows that there is something going to happen very soon, perhaps if he allows him to go, the police will also not allow him to come early to do his parliamentary duty. So
we know the speaker's reason. The speaker's reason is that they have started their work from now until December.
Mm-hmm.
Yes, that's it. That's the reason.
Oh, that because we have the last one. I strongly believe that the speaker is quite aware of their agenda for the remainder of the year, and he knows that perhaps very, very important bill or something that will affect the whole nation is around. That's why it's not allowed that.
Okay.
I don't think he can be capricious.
All right. Thank you. Thank you very much, S.N. Dakwa, who has served, elder statesman, we should say, who has served both from the first to the fourth Republican Parliament. And this is where we take a break. I read just one small message as shared by H. Kwesi Prempeh, and a part of it he says that Professor H. Kwesi Prempeh, he says that in democracies across the common law world, it is fairly common for MPs to be arrested, charged, prosecuted, even convicted. And while it makes sense that the Speaker would be notified of an MP's arrest, charging, prosecution, or conviction, the law and practice in these matters typically do not give the Speaker a mandatory gatekeeper or pre-clearance role or veto over the decision or actions of the law enforcement authorities in respect of an MP. The one privilege of an MP that may not be questioned by anyone in any forum outside of Parliament, including in a court of law, relate to speeches made or matters said by an MP in the course of the business of the House. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis show. Unfortunately for the law school and legal education reform issues, we can't do beyond 5 minutes for it. We apologize for our next set of guests because it was not intended that we will discuss this matter for that long, but it got very interesting. And it is important that we bring some finality at our end to it. It does appear that until there is a pronouncement from the Supreme Court or there is a certain agreement between the police and Parliament, this matter will continue in the manner that it keeps coming up. Kaswa Brantier, Andy Larry says that unequivocally the standing orders and the ultimate privileges of the parliamentarians should be reviewed. The impunity and abuse of power privileges are highly appalling. Equality before the law is sardonic and purely shenanigans in the country. K. Amofa, you need to protect your MPs too, you know that. K. Amofa says that the problem with the Speaker's decision not to release Honorable Sosu is worrying under the charge of criminal nature. Well, elsewhere they have stated how long you can decide not to, you are attending to or and this, and they have decided it's only maybe 5 days. Beyond that, the Speaker can't do anything. Papa J, LACM official, says the Speaker needs to be informed and be notified of any intention or arrest of any MP. It is very important. Nana Yao says that, he's replying, LACM says that the police is not powerful, but the law is. If a celebrity has been arrested in that same powerful process by the police and they obeyed, what prevents a parliamentarian from doing so? Don't we want the police to work anymore? And then Musa Abattoir says that the Constitution is clear on what the police should do. Unnecessary tension in public domain isn't helpful. Separation of powers, which indicated that Speaker of Parliament is third in command. Therefore, police must accord him with the needed respect. Proverbial tutor Kofi Amwa said, did the police drive on good roads to go witness the demonstration? Unfortunately, because of this, the purpose of the demonstration has been lost. Whether those roads are being fixed. We just been told by some reporters that they've gone there and seen that contractors are back. I mean, why were you waiting all this while to fix these roads? We only have to fix the country together, and it will be practically impossible if we will use each other against ourselves. Never ask your silence MP for roads. Charles Rekurobe says, all roads are leading inexorably to the Supreme Court. Parliamentary privilege. Prince Henry Koforidua says, the police needs the legislature, same as the legislature also need the police to maintain peace and order. We don't have to be fighting each other. And finally, Eliasu Intamale says that the immunities enjoyed by the MPs have limitations, while the attempt at shielding him. I couldn't agree more with the police to seek interpretation on the above issue. Thank you. Now, like I said, I will take just about 2 minutes each from you, straightforward, what should be the way forward for legal education in Ghana. 144 students is what has led to all of this. They said they made a 50% pass mark, and later they said they discovered that the school is saying that you must make 50% pass in the 2 sections of the exams that you wrote, and not just 50% cumulatively. Now, they have been trying, things have not worked, so a majority of them are in the court. Whilst that was happening in the course of the week, Parliament passed a resolution. It appeared to be unanimous, directing the Board of Legal Education and the General Legal Council to admit them and to expand legal education. Some MPs, 2 of them, Nelson Dafiamapo and Francis Xavier Sosu, are also sponsoring a private members bill to expand the access. And they are also asking that the Chief Justice and other Superior Court judges who are on the General Legal Council should be removed. What's the way forward? Start with you, Dominic.
Well, I think that the reform of legal education, especially at the professional level, is long overdue. I remember as a Deputy Attorney General speaking on behalf of the then Attorney General in 2015 at the Bar Conference in Kumasi. The Attorney General made a call for the reform of legal education. Somehow or another, that didn't happen, prior to our exit, from office. But we in the NDC are still committed to that position that we took, that there is a need for a comprehensive reform of legal education that will, increase access without compromising quality. And the two are not necessarily, how will I call it? And in conflict, okay. Because you can actually increase access and then maintain, quality in the provision of legal education. So our position is that we allow the law faculties, such as professors, school, UPSA law faculty, to run the professional law courses, and they should be limited to what is needed for someone to practice at the bar: civil procedure, criminal procedure, the conveyancing and drafting, and then ethics, advocacy and legal ethics. Okay, and that these should be run by the faculties as clinical, these legal courses, and then there should be a national bar exam that is written by all persons, certified by the faculties as having, done the clinical legal program, and then they are called to the bar. That way, you do away with this whole notion of lack of, physical infrastructure to accommodate, a large number of students and so on. And something that in our region, Upper East region, okay, together with the state attorneys, we don't have up to 10 lawyers. So the whole idea that there are too many lawyers in the country, is not well founded as a matter of fact, because. And I think our situation is even better than Upper West. Okay, so I think that in a nutshell, the overhaul of the legal education system, especially at the professional level, is long overdue. The bill that Honorable Sosu and Dafia Makwa brought is one that is meant to amend Act 32, so it's limited in scope. But I have been working on one myself, pursuant to the 2015. The 2015 position that we took in Kumasi, and I am supported by the Honorable Muntaka and then Honorable Patrick Boama, all right, on the the MPP side, right. And ours is a more comprehensive bill that will also be a private member's bill that will be submitted, early next week to Mr. Speaker. Right. So definitely we are, garnering support for the overhaul of legal education in Ghana.
Right. And you just mentioned something. In the whole of the 5 regions up north, you have 39 lawyers.
There you are.
39 lawyers.
That must include the state attorneys, because usually when they count the lawyers, they count the state attorneys.
Yes, and in the Upper East, our place is more specific. You have only 14 who are serving a population of 1.3 million. But, Prof, you are training the lawyers. Is this not a question of quality? And sometimes it looks like we are talking, but we are not conducting surveys to inform what we need to say. Is it really the problem with Ghana? Because I've been reading a survey that was done in Kenya, and it's not impressive at all. In July 2017, you had 2,018 students who sat the exam, and you had 783 who passed. And then in July 2018, you had 2,097, 67 passed. So there was 39%, 32%, and then 2019, you had 2,178 and only 846 passed. That's 39%. And the survey says that students perform better in a particular setting when they have the opportunity to have tried the first time. Then they begin to know all that is the requirements that is going on. The research also says students with better high school grades are found to have gone all the way to do better in the law exams. So it's the quality. How are you churning out? They are actually suggesting that people should have the opportunity to do pupillage before they sit the bar exams.
Well, various suggestions have come up. Some are even recommending that we should have mandatory national service. It used to be the case, and they took it off. Mandatory national service, so people mature in.
You used to need a first degree first.
You need to, yes, but there used to be a requirement that after your LLB you needed to do national service before you go to the law school. Some have argued that that period allowed for some maturity. In fact, I can tell you that from our own trend analysis within law schools, the law schools I've been in, from our own trend analysis, you can tell that students who have first degrees tended to do well in certain areas of particular subject than students who didn't have first degrees.
Right.
And students who didn't have first degrees, also, in other words, students who have first degree tended to have maturity characterizing their answer, and students who didn't have first degree tended to have better industry. Better industry in the sense of they were younger, they exerted more, they were able to study for longer hours and all that. The long and short of all these is that we have a problem with legal education in Ghana. Nobody can dispute it. The second thing is the General Legal Council for the past 5+ years, number of years, have been embarking on all kinds of reforms. These reforms have had various degrees of successes, and it's imperative that we actually streamline the reform properly. I don't think that we've done as well as we could have done. There's a lot more room for improvement. But I worry about politicians and political participation in educational reform. Now, I have said it's not just for legal education, I think generally, because political pressures tend to exert certain influences that often are counterproductive. And I'm just saying this because my very good friend, Honorable Dr. Dominic Ayina, sitting here, he has a constituency. The constituency exerts pressures which may be otherwise than for the rational good of a particular reform. Their interest is let our sons, let our daughters become lawyers. They're not really interested in the mechanics of that. Just help us get there. So when you have parliament, when you have political actors taking the forefront of legal educational reform, including parliamentary directives, while these may end up unintendedly achieving good results, I think that in the main, they tend to be counterproductive. So I think that one thing we haven't done is we haven't done the concerted effort of reform. Deans of law schools, law teachers, the Bar Association, these three entities in particular have not taken active role, the front seat in legal educational reform. The people who produce the people who hold the Bachelor of Laws, these are the faculties. But very often they have been consulted after the fact. They are hardly consulted before things happen. And I can tell you that the proposed removal of the Chief Justice from the General Legal Council, it may not necessarily solve the problem at all. Some people have questioned why judges and co should be in the General Legal Council. But the Chief Justice, and speaking personally about the current Chief Justice, I was privileged to have actually been with him on some rounds across the country doing vetting of law schools, reviewing and I think one thing I can speak for him personally, as far as legal education is concerned, is that he's extremely passionate about quality. It is part of the reason some people think he's hardline, because I think the inspection that we did across the country. His children
didn't pass.
Correct.
And they went
they're out
to
of the country.
countries.
That should tell you something. Look, the inspection we did across the country, I think, may have exposed him to some shock. And that shock may be influencing his reaction. Because to be honest, you go to some places and you can tell that there's the desire to run legal education, but beyond the desire, there's nothing.
No facilities.
And so we have a problem. And some people say this. You're mentioning figures from Kenya.
Right.
The professional courses such as ACCA, the failure rate is even more atrocious than this. The difference between this and legal education is that in the case of legal education, you find them in one space. And so when people fail, you see it. So nobody should get me wrong. I support the additional admission of students who pass. Anybody who pass must be admitted. I support the expansion of legal education, access and equity. I support the fact that things need to be done. But one has to be careful not to create another problem as we try to solve one.
All right. Thank you so very much. Unfortunately, I suppose that there will be a proper clinic during which we must interrogate these issues a lot more. Thank you so very much.
I can say, here on your, if you will allow me, that the Dean of the University of Ghana Law School, Professor Atuga, is organizing a conference, a kind of global conference on legal education in December.
Right.
And he has graciously invited me to be part of a panel, including Asan Kuma and a lot of other senior lawyers.
Thank you also very much. My guests for the first segment have been Dr. Dominic Ayene, who is MP for Bolga East and former Deputy Attorney General and Minister for Justice. Professor Kofi Abochi is Dean, UPSA Law School. Martin Pebu joined us earlier. He's a rights activist, he's a lawyer, and then statesman SN Dakwa, former clerk of Parliament, who has been with the first to the fourth Republican Parliament, joined us. Thank you also very much. I have Dr. Gideon Boakon, spokesperson and aide to the Vice President, joining me. Professor Samuel Chinibua Kodia, Senior Lecturer, Gempa School of Technology, joining, and also Godfred A. Bokpeng, Professor of Finance and Economics, Economist, University of Ghana. They will join us. My apologies to you, gentlemen, once again. We'll be right back. Professor Abochi will still be with us.